Good afternoon, everyone. Thank you for joining us, and a warm welcome to everyone who is with us on this seminar today. This is part of a regular series of seminars we're running to support our clients, communities and colleagues in these difficult economic times. Our seminar today is on improving cash flow during coronavirus. Our audience is predominantly directors of businesses, although we also have some intermediaries and accountants who we believe will find this useful as well in having conversations with your own clients. The coronavirus has been a real challenge for businesses, both in terms of managing cash flow with the practical issues that it presents, but also because of the knock-on effects of some changes to the law, which in turn is constricting certain things that creditors can do and making things different and in some cases easier for certain debtors. And that's something that we're going to be looking at today. I'd firstly like to introduce my colleagues who will be on this presentation as well. And they are Jonathan Sachs, who's a partner in our litigation team in London. Richard Payne, who is a senior associate in our litigation team in Leeds, and myself in the restructuring and insolvency team at Owen Mitchell. Prior to this event, we have had some Q&A and some questions have come in. And if during the course of this event you would like to raise any questions, please do feel free to do so on the Q&A function, which is on the tab when you're viewing this. And additionally, if anything comes to mind which you would like to ask us afterwards, please feel free to do so and drop an email to us at events@owenmitchell.com. This is part of a weekly series of events, and if there's anything you would like us to cover going forwards which you think would be of interest or useful, please again do feed this back again to the same email address. Now, without further ado, I'm going to pass over to Jonathan, who's going to be dealing with some changes to the law with landlords collecting rent and the general experience that we're having at the minute with litigation in the courts. So, Jonathan, over to you.
Thank you very much. Yes, I've had the misfortune of experiencing two recessions, the 1990 to 1992 recession and also the recession of 2008 to 2010 as a solicitor. I think what's key to me in my experience of those two recessions is that those who get in first may recover their debts or win their cases. Those who get in first may get charging orders over property before other creditors get charging orders over properties, or may be able to instruct High Court enforcement officers who will be able to get in first before other creditors. So although I know that the government has encouraged creditors and debtors and suppliers to cooperate with each other and to try and compromise matters, I think it's very important that that not be overstressed. The pre-action protocols for debt and the general pre-action conduct protocol contains a process which in essence deals with what the government's requested. The most radical changes under COVID are in the commercial and residential rent recovery arena. For commercial landlords, a very effective method of process was to ask commercial bailiffs to seize goods when arrears of rent occur. This can't be now done if the arrears of rent are only 7 days. It now has to be a 90 days arrears. As Tom and Richard will explain later, there is a moratorium on the service of statutory demands on commercial tenants, so that won't be able to enable you as a landlord to recover your rent. There's restrictions on landlords' ability to forfeit business tenancy and also claims for possessions. In effect, until the 23rd of August occurs, you won't be able to obtain a possession order in respect of commercial or residential premises. But what can you do? Forgive me, I'm not doing very well with these slides. Well, I think once you've gone through the protocol, I would suggest that you do issue your claim for possession. The county court, it's not the moratorium is not preventing companies and individuals for issuing a claim for possession. It's just that the proceedings will be stayed the minute the possession proceedings are issued. But there's going to be such an enormous backlog in most county courts that the best thing to do, I would say, is to issue your claim now and wait for the moratorium to end. The other way of putting pressure on your commercial residential tenant, if you cannot negotiate a compromise, is just simply sue for the rent only in the online court, where if you only have one defendant, you can make a claim for sums of under £100,000. And I wouldn't wait. If you can't reach a compromise and you feel that you want to put some pressure, I would just issue a claim for the actual rent. What have the effects of COVID been? On High Court litigation, very little. Now, I know a lot of this will be quite well known to people, but I think that it's very sensible to realise that if you do have a claim for over £100,000, please do issue it in the High Court, because if you're going to proceed with your claim, you're not going to have much success in the county court at the moment. My view, it's sensible to issue claims in the Queen's Bench division of the High Court, as the process in the Queen's Bench division is much simpler, and the Queen's Bench division masters are pretty robust. So if you issued a claim for £110,000, I think you could follow it up with an application for summary judgment. There are difficulties of issuing in the commercial court and the chancery courts because of the new Practice Direction 51U. Under this practice direction, there's an obligation to have detailed directions on disclosure of documents. All documents need to be disclosed in a native format, and there is no prospect of a speedy agreement to the process to go headlong onto trial. So I think at the moment, where time may be of the essence, I would stick to claims in the Queen's Bench division. Now, what's happening in the court? Well, hearings are still occurring. They're not being adjourned. They're mostly remote hearings under Skype business. And I think that you need to be prepared that your hearing will not be adjourned. The judges are requesting small hearing bundles, and here again you need to be very careful. We have very skilled assistant solicitors who can cross-reference with cases with hyperlinking, and the bundles need to be searchable. But certainly in the High Court, as far as I'm concerned, actions are proceeding. The PCB Barclays Bank case is proceeding remotely, with witnesses being cross-examined over Skype, and with transcription services providing live transcription. Let me see. The county court, though, is a very different beast, and there are real problems occurring in the county court. The online court is still functioning properly for claims against one defendant, and I would stress that you use that. But you can only issue proceedings on the online court if the claim is for under £100,000. It's a debt claim, and there's only one defendant. The problems in the county court are occurring immediately upon defences being filed. The Central London County Court has in effect ceased to function. It's only listing urgent matters, which would be matters which are required because there's a trial date coming up or because they affect children, and it's in effect ceasing to properly function. I've been waiting for a consequential hearing after striking out a claim since January, and I've written 26 emails and made 3 complaints without any success at all. The time for cases now coming on is rapidly increasing. Most fast-track cases for under £25,000, £10,000 to £25,000 are now up to a year in waiting for those cases to occur. For cases over £25,000, it's much more than a year. With regard to the small claims track, even the small claims track, I think we're now up to 40 weeks for a case to occur. It's a terrible system, and it's just not fair at all for members of the public who may have paid quite substantial court fees. So what's the alternative to High Court and County Court litigation? Well, I think we need to seriously consider using arbitration clauses in our terms of business. If you get an arbitration award, you can apply for summary judgment to enforce that arbitration award in the court system. I think it may be cheaper now to use an arbitration, and certainly if there are going to be issues with regard to Brexit, it may be easier to enforce your arbitration award overseas after Brexit. There also may be a sense of a high level of justice. You can choose who your arbitrator is going to be. You don't need to rely on the vagaries of the county court system. You can also agree to have a paper arbitration where there's no judges. I think there also should be a greater use of adjudication in professional negligence cases, construction cases. I think a high level of justice can be done by just simply referring papers to a barrister for a barrister to decide an issue in professional negligence cases. It can be a temporary decision, but it may be a decision which both parties are able to agree to. Zoom mediations are working quite well. I would have a word of warning. I've done free Zoom mediations. I think physical presence has a real effect, and I think it's easier to settle a case if you can actually have an in-presence mediation. One method we did use with an opponent who I get on well with is that for £500 we did a blind bid mediation, where basically we got onto Zoom and each party made a blind bid to settle the case, and the mediator decided whether it was worth continuing. Eventually we got up to £110,000 for my offer and £100,000 for their offer. Not surprising, it settled £105,000 and we only spent £500. Finally, on the issue of collecting debts, and in particular for High Court litigation, I think you need to be beware of issues of service on sole traders or partners if their business is not working. Under the rules of service, you need to serve a sole trader or partnership, the old-fashioned partnership, on their last known business address. But I can see plenty of arguments that if you're not trading because you're in lockdown in your business, then if you send a claim form or a letter of claim to an address which is not actually working, whether that is actual proper service. So I think you need to be careful that maybe you need to do personal service on sole traders or partners. Of course, with companies, you still carry on serving on registered offices. Well, I think that's my end to my gallop through the effects of COVID on litigation, and I'll pass you now on to Richard. Thank you.
Thank you, Jonathan. There aren't any slides for this particular part of the session, but if you want an overview of what I'm just about to cover, please get in touch and I'll happily supply that. I intend to rattle through this as there's quite a bit to cover. I'm intending to take a look at one of the key points of the Corporate Insolvency and Governance Bill, which is currently going through Parliament and is likely to come into force by the end of this month. In particular, I'm going to cover the temporary restrictions on the use of statutory demands and winding up petitions. But first, let's remind ourselves of the procedure. Statutory demands can only be used for debts that exceed the current threshold of £750. If a debtor company is on the receiving end of a winding up petition, it must deal with it promptly as it will have serious consequences and may well lead to the company being placed into compulsory liquidation. A statutory demand is a document prepared by the creditor, or usually its solicitor. It's not issued by the court, and no fees are payable, certainly not at that stage. It sets out brief particulars of the debt and essentially states that unless the debt is paid or secured within 21 days of the date of service, then a winding up petition that may be presented. A statutory demand is usually served personally at the company's registered office. Address, the fee for that's normally about £100, and then the creditor then has to wait 3 weeks to see whether or not the company responds. If the company disputes the debt, it does not apply to the court to set aside the statutory demand, as is the case with statutory demand served on individuals. Rather, the company should write to the creditor setting out the grounds on which the debt is disputed, providing evidence in support if possible, with the ultimate aim of obtaining a written assurance from the creditor that it will not issue a winding up petition. Failing such an assurance, the company should apply to the court for an injunction restraining the creditor from presenting a petition. In order to obtain an injunction, the debtor company will have to satisfy the court that it either has a genuine defence or a substantive counterclaim that, if established, would operate to reduce the amount due to the creditor below the £750 threshold. As many of you will probably know, injunctions are particularly expensive things, particularly commercial injunctions. If part of the debt is disputed, the debtor company should pay the admitted element and then follow that procedure in respect of any disputed balance. Having said all that, most creditors do not issue statutory demands as a precursor to issuing winding up petitions. It's simply not necessary in the case of company debts. Instead, a winding up petition can be presented based on a simple letter of demand that is usually sent by first-class post, and email stating that a petition will be presented in the absence of payment within, say, 3 days. It could be shorter, it could be longer, but I would say that 2 days is probably the minimum, unless there are very good reasons. In these circumstances, the petition is based on section 123 1E of the Insolvency Act, i.e. where it is otherwise proved to the court that the company is unable to pay its debts as and when they fall due. A very useful authority for this, which is regularly cited, is the case of Cornhill Insurance plc and Improvement Services. In that case, Improvement issued a winding up petition based on a simple letter of demand, not a statutory demand, claiming something like £1,200. The challenge by Cornhill was not that the debt was disputed. It was accepted that the debt was due, but rather that Cornhill, as was common knowledge, was not insolvent, far from it. And as such, the creditor could not base a petition alleging that it was insolvent. The court in that case disagreed, holding that if a company, no matter how wealthy, does not pay its debts as and when they fall due, the creditor is entitled to infer that it is insolvent. As with the statutory demand, if a company receives a letter threatening the issue of a petition and it claims to have a genuine defence or a substantive counterclaim which would operate to bring the undisputed element of the debt to below the £750 threshold, it should seek assurance from the creditor or its solicitors that it will not present a petition, and failing that, apply to the court for an injunction restraining the presentation of a petition. The court fee on issue of a petition is £280. At the same time, the creditor must also pay a deposit to the official receiver, who is appointed provisional liquidator in the event that a winding up order is subsequently made. The deposit is currently £1,600, which that's £1,600, which puts some creditors off from issuing petitions. However, if the creditor does not proceed to obtain a winding up order for any reason, i.e. because it's been paid, or the company has gone into creditor's voluntary liquidation or similar, or it has simply had a change of strategy, if the petition is subsequently dismissed, then £1,550 of the official receiver's deposit will be refunded to the creditor. The £50, so the difference of £50 is held onto by the official receiver for the privilege of holding all these deposits from creditors. The petition is given a hearing date, usually within 6 to 8 weeks of presentation. It's then served personally at the company's registered office address, and again, process servers are in the region of £100. If the company ignores the petition, then the petitioning creditor can advertise, but it cannot advertise until at least 7 clear working days have elapsed following service of the petition, and if it is to proceed with the petition, it must advertise at least 7 clear working days before the hearing. Advertising the petition will have serious consequences for the company, because on seeing the advert, the company's bankers will freeze its accounts, suppliers may stop supplies, and other creditors may well support the petition. Therefore, timing of the advert is crucial, and in most cases it is sensible to warn the debtor company, and certainly bring the petition to the company's director's attention, advising them that unless immediate arrangements are made to settle the petition debt and costs, then the petition will be advertised. The company can oppose the petition at any stage, but if it intends to do so, it's likely that it will do so before the petition is advertised at the very latest. If necessary, the company can apply to the court for an injunction restraining advertisement of the petition and seeking the removal of the petition from the file. If the petition is successful, i.e. it results in payment, the petition can be withdrawn prior to the initial hearing, provided it has not been advertised and there are no supporting creditors. If it has been advertised and there are supporting creditors, the creditor and the company must wait for the hearing before seeking its dismissal. a supporting creditor usually has the right to be substituted as petitioner at the hearing if the petitioner does not seek a winding up order at the hearing for any reason, for example, because it's been paid. If a supporting creditor is substituted and subsequently proceeds to obtain a winding up order on the petition at the adjourned hearing, any sums paid to the original creditor after the date of presentation of the petition are likely to be reclaimed by the liquidator under section 127 of the Insolvency Act. This is why timing of the advert is crucial, as supporting creditors can and often throw a spanner in the works. Petitions are more than often the most effective means of putting pressure on a debtor company to make payments. And in practice, if the company pays the petition debt and interest, if applicable, it will usually also agree to pay all or most of the petitioning creditor's costs. As some of you may know, there has been a dramatic increase in recent years on court fees. Court fees on the issue of a claim form. They are now 5% of the claim value, subject to a small discount if you issue online, and subject to a maximum fee of £10,000. So were you to issue a claim for £20,000 in the county court, the court fee alone would be £1,000. If one takes the official receiver's deposit out of the equation, which, as I say, is refundable, save as the £50 admin fee, then in my opinion, winding up petitions represent very good value for money, and in many cases will be cheaper than issuing a claim form, obtaining judgment, and then trying to enforce that judgment by either instructing the High Court enforcement officer, for example, or seeking a charging order, which is unlikely to bring about payment in the short term. In my view, creditors should consider basing a petition on a simple letter of demand rather than issuing a statutory demand, or after obtaining judgment. I caveat that by saying once again that they should not be used where there is a substantive defence or a counterclaim, and obviously winding up petitions are likely to bring an end to any commercial relationships. But then again, I suspect that the same can be said of any court process. Now, having said all that, in response to COVID, the government published a bill on the 20th of May known as the Corporate Insolvency and Governance Bill. The bill is designed to help businesses struggling with the effects of COVID, and part of those measures are to place restrictions on the use of statutory demands and creditors winding up petitions. These restrictions are intended to be temporary measures. The measures include a bar on the use of statutory demands. However, as a creditor need not serve a statutory demand, as I've just explained, as a precursor to issuing a winding up petition, then I need not dwell on those provisions. The bill, if enacted in its current form, will prohibit a creditor, that's any creditor, not just commercial landlords, from issuing a petition unless it can prove that either the company's finances have not been affected by COVID, or that its inability to pay existed before COVID, the relevant grounds as they are frequently referred to. the court will not make a winding up order or even allow the petition to be advertised unless the creditor discharges the burden of proving one of the grounds. Thus, we are likely to have at least 2 hearings of winding up petitions, whereas in the past there is just usually the one. The first ground, of course, is going to be very difficult to prove, as the creditor does not usually have access to the company's books and records, and of course many businesses have been detrimentally affected due to COVID, unless of course the only source of business is producing face masks or hand sanitizer or something of the sort. As for the second ground, in practice it will probably be sufficient to demonstrate to the court that the debt became due for payment before the lockdown. To avoid risk, I think it would also be desirable to have some evidence, such as an email from the company prior to lockdown acknowledging that it was unable to pay at that time and offering to pay at a future date or by instalments. The bill, if passed in its current form, will have retrospective effect. It will affect petitions presented from 27th April to 30th June, or 1 month after the legislation is enacted. If it comes into force at the end of this month, which is what is envisaged, it will run until the end of July, although I wouldn't be at all surprised if it is extended slightly. In fact, even though it hasn't yet been enacted, the courts have already started applying its provisions. In a recently reported case, an unnamed but well-known high street retailer managed to obtain an injunction from Mr. Justice Morgan restraining a creditor, in this case one of its landlords, from presenting a petition. The judge held that the bill was likely to be enacted more or less in its current form, and that the creditor was unlikely to meet one of the relevant grounds. There have also been a number of other unreported cases where the courts have had regard to the bill's provisions. Finally, any winding up order made between the 27th April and the bill coming into force, where the relevant grounds are not met, will be treated as void, and the court will give directions to restore the company to the position it was in immediately prior to the issue of the petition. Precisely what that will mean to the petitioning creditor remains to be seen, but surely it will not be held liable to the company for any damage sustained by the company in circumstances where the court correctly made a winding up order. Anyway, that's that from me. I shall pass you over to Tom.
Thank you very much, Richard. So what we have here is not just the coronavirus itself, but we have obviously the actual changes to laws and procedure from the government that are having an impact here on being able to collect in debts. And as Jonathan said before that, just the practical issues with the courts themselves. This is all creating a bit of a perfect storm for cash flow. And we've been focusing up until now on the impact on this for businesses themselves. And what I'm going to now look at is the consequences for directors personally, because although limited companies do have a degree of protection to isolate the directors from personal liability, there are various problems that directors can and probably will fall into in this mess that we're presently in as an economy. So what are we seeing at the minute? Well, in my world, where I'm assisting both debtors and creditors in trying to resolve cash flow issues, we're seeing debtors struggling to pay all of their creditors, be it lenders, trade creditors, landlords, tax, employees, etc., and they're seeking to agree agreements with those creditors. The creditors, in turn, are finding that even if they started coronavirus in a fairly strong position, and even if their business isn't necessarily too affected by coronavirus, they are still finding issues arising because debts they normally would have been able to collect are trickier, and they're reaching the limit of their own limits in terms of the lending that they have and tax and salaries, etc., that they're having to pay. So they're running out of options other than to go after those debts. But as Richard has said, that's tricky in terms of one of the tools in their toolbox, which was statutory demands and petitions. That is in some instances not going to be possible now. And in other instances, as Jonathan said, it's going to be very slow progress going through the courts. In terms of what's happened so far, well, the government's trying to prevent this perfect storm happening at the minute, and a lot of this, unfortunately, is just kicking things down the road. As Richard has said, there's been a ban on certain enforcement procedures, or it's likely to come into place if the bill is approved. There's the coronavirus job scheme, there's deferring on VAT, certain grants, loans, and HMRC time to pay agreements. But the elephant in the room here is that other than grants, all of these things are not making the issue go away. These are either adding more debt onto companies, which they're going to have to pay in due course, or they're just delaying existing debt. That debt isn't being wiped clean. So when the lockdown properly ends, even if demand for those businesses goes back up to 100%, they're going to have to find a headroom to pay these historical debts. And in some cases, that's just not going to be possible. In terms of the duties and what the directors owe and how this intermixes with these issues that businesses are having, normally directors owe their duties to the shareholders. That's when the company is solvent. But when the company becomes insolvent, then those duties flip and they're owed primarily to the creditors. And that requires directors to think in a completely different way to what they're normally used to. Those duties they're set out in the Companies Act 2006, and they're extremely wide-ranging. In every business, there's going to be specific circumstances that give nuances to how those duties are interpreted, but in a very broad brush approach, those are acting within the powers of the directors. In other words, every company has articles of association which set out what the directors' powers are. Now, directors may not give much thought to this normally because a lot of more recently incorporated companies will have very wide powers, but companies that were incorporated some time ago, perhaps more than 20 to 30 years ago, and they haven't changed their articles, there'll be limits on what those directors can actually do. They also have to promote the success of the company, which seems obvious, but where a director is a director of more than one company in a group situation, sometimes that is not actually an easy thing to cover on all of those companies. And likewise, where the director might have other business interests in other businesses which are in some way in competition with the company. Exercising independent judgment, again, in a similar way. Reasonable care, skill and diligence is another thing, and where we see that coming undone a little bit is where directors entrust other employees or other directors with doing certain things, and they don't then put things in place to monitor or ensure that the person entrusted with that delegation is carrying out that properly. Avoiding conflicts of interest, again, that's a fairly obvious one with group situations, as is not accepting benefits from third parties. Declaring interest in proposed transactions or arrangements, well, the obvious one where that comes up is where a director is involved with the company transferring its assets, say, or entering into a contract with another entity which they're also a shareholder or a director of. So these are the broad things which directors just need to be aware that they owe. And how are these breached? All kinds of things. The obvious one of the obvious ones is omissions or actual positive actions causing loss. One example of this would be entering into a contract which is completely uncommercial, subjectively or objectively for the company, and then that causing the company a great deal of loss, transferring assets at less than market value, and also preferring certain creditors. I'm going to come on to the preferring of creditors in a minute, because that's a dilemma that a lot of businesses have, where they can't pay everyone, but they maybe feel that paying certain creditors may enable them to continue the business and then go on to bigger and better things without being able to pay everyone. Remunerating directors, again, I'm going to come on to that in a second, because that's another thing that directors will fall down on and really get caught out if the company later goes into liquidation, as is declaring of dividends, where that declaring of dividend might be a force of habit with previous management of the company, where everything's been fine with profits, but they find themselves then in a tricky situation where there aren't those profits. Also acquiescing to the actions of other directors, because if you have more than one director, it's not necessarily the case that if one director is dealing with everything and there is an issue of a breach, the other director who's not involved it is not going to be liable. It's expected that so that harm or loss to the company is not going to be caused by that director necessarily. And wrongful and fraudulent trading. So I'm not going to go into a great deal of detail about this, but essentially the government has put wrongful trading on hold, which is where a director fails to stop the company trading when they know that it could have when they know it could not have avoided insolvent liquidation or administration, and the delay in doing that then results in a loss to the company, usually from its balance sheet, before it actually does go into liquidation. The government, there's been a lot of sort of press around this, where they've tried to prevent there being any relief that a liquidator can seek on wrongful trading for that situation, but it doesn't cover fraudulent trading where the director knowingly does that and is knowingly causing that, and it's also not going to be permanent. It's going to come back online in due course later this year. So in terms of the implications for the breach, well, in good years, when a company is solvent, even if a director technically breaches their duties to the company, the shareholders can ratify that breach, and that's often the case, and it does happen where the director and the shareholder are the same person. So the obvious thing there would be where a company, for example, will transfer an asset out of the company for no consideration to either the director themselves or to another company, and that could be a technical breach because market value hasn't been given. But if the company is solvent and it's the shareholders that are losing out on that, and they ratify that and say they're fine with that, then that can be a defence to that kind of claim. The problem directors have is that where the company is insolvent, and they might not even be aware at that time it's technically insolvent, those shareholders, their view on it is largely irrelevant. It's the creditors who the duty is owed to, and in practical terms, it's not going to be possible to obtain their ratification of that breach. So if the company then goes into liquidation or administration later, the office holder, the liquidator or administrator, will investigate things such as asset transfers or just general transactions, and they will look as to whether there's been a breach or causing a loss to the company by the director, and they may look to bring proceedings against the directors personally. So this is an example, perhaps in the SME sector, of something that can and does happen. And it might be something that companies are facing at the minute, and directors have to give really careful consideration as to what the next move is. It is going to have personal consequences for them. So let's say, for example, we have a company that at the minute can't pay all of its debts. It's got some cash there, and it decides to make several payments, and those payments are to ABC Limited, which is one of the company's creditors, and the directors choose to make that payment because they've given personal guarantees to that company, and they're concerned about their own position if they fail to pay that company. So they decide to pay that company £50,000. They also decide to pay DEF Limited, which is one of the company's suppliers, £100,000. And their reasoning for that is that if they had set up a separate business in due course, a separate company, if the existing company goes under, they see that supplier as key to that new business, and they want to keep that business on side for direct purpose and goodwill there. They also decide to pay their remuneration via dividends, because that's the way they've always been advised to do it, for tax reasons, and they pay £20,000 during the relevant period. In a future liquidation, the starting point is likely to be in that situation that the liquidators will pursue a claim against the directors personally for misfeasance for £170,000 being the sum of those amounts, plus statutory interest at 8% going back to the date of those payments, plus costs. So straight away, the directors are looking there at a potentially £250,000 claim. And yet they may have felt that really they'd only pocketed themselves personally that £20,000 remuneration element, but this is what they will potentially be on the hook for. So what can creditors do to avoid getting into this sort of situation with a breach? Well, the first thing that, of course, Owen Mitchell would say, being lawyers, is to seek legal advice, but it is really true. Some of this is practical judgment, and it sometimes it seems obvious with a little bit of background knowledge on duties and how they're breached, but sometimes it's not. Real dilemmas in terms of making judgment calls for directors as to when to make a payment or not, and how to conduct the business during an insolvent period. Secondly, to seek the input of restructuring and insolvency practitioners who can provide solutions where the company is insolvent and it is going to be a case of paying creditors part of their debt rather than all of it, but then that needs to be structured in a formal way with a process where there's no comeback. Also, to retain records and correspondence, because in the future, even as the directors have acted correctly and they have either mitigated the loss fully or they just simply have a cast iron defence, the directors won't necessarily be able to evidence that with fading of memories and the loss of the company's books and records when those are handed over to the liquidator. One of the common things we see is that the directors have everything very well documented and it's all saved on the company's server. The company then goes into liquidation and it's then really difficult to retrieve those records because the fees for the server have not been paid whilst it's been in liquidation and everything's wiped clean. So directors would be well advised to either ensure that the liquidator keeps those records safe or to somehow obtain copies of those at the outset of the liquidation and ensure they're kept in a safe place. In addition to that, so many business decisions, even with larger companies and businesses, are dealt with verbally. They're telephone conversations, face-to-face conversations, etc. It's really imperative that, especially in times like this, where companies are facing cash flow issues and making really important decisions, that they are noting those decisions that are made other than in email and letter, or even minuting those when they're really key critical discussions. It is really helpful to persuade a future liquidator to have those in place. It just, apart from giving an actual material defence, it gives a veneer of respectability and compliance with duties to the liquidator, and the liquidator's perhaps less likely to be second guessing the director's motives on any given decision then if it's all been done and recorded properly. So in essence, I think at the minute, what we are seeing is unprecedented in terms of the volume of businesses in the economy who are simply not able to pay their debts as they fall due, and they have these cash flow issues. And it is going to come to a head more and more because as some of the restrictions which Richard mentioned ease themselves and winding up petitions to make a comeback, companies going to be forced with a decision whether to pay certain debts or not, or just to go under. The key message on all of this is to seek advice at an early stage. Apart from just protecting the director's personal position, it also might genuinely be the way of unlocking a way of continuing the business and saving it, whether through a formal process or something more ad hoc and flexible with creditors. I'm now going to turn to one of the questions that we've had and we've been given, as it's kind of interconnected with this. And that is, sorry, just bear with me 1 second. Are businesses in risk of overtrading once they exit lockdown, i.e. if cash flow forecasting is not robust enough? That's very much the case, yes. And in actual fact, in previous recessions, in both the recessions which Jonathan mentioned before, the spike of companies going into insolvency processes was not during the worst part of the recession, it was coming out of it. And the reason for that is that during recessions, even when the government doesn't put in place things that they have at the minute, where they're trying to keep companies going with loans and grants, companies tend to batten down the hatches and survive actually the worst part of the recession, and it's coming out the other end when they overtrade. They don't have enough finance to keep things going. They overextend themselves on promising to clients, and they sometimes can't get the necessary supplies in that they need to then service those orders, and they come undone. So again, companies coming out of the recession, they need to be engaging with their accountants and their lawyers on this kind of situation. If there is a concern, particularly where the accountant raises this, that the company is going to be unable to deal with that kind of order, or it's going to be tricky, the directors really need to be taking legal advice or considering this very carefully in terms of their personal position, because if they're getting that advice that it is a risk and they overextend themselves, that could be a ground for misfeasance if the company then does fold and goes into liquidation, and the directors may be personally liable in that kind of situation. So that might seem a bit back to front coming out of it and everything looking potentially rosier and orders coming back in, but it is really the way in the past recessions we've seen companies trip themselves up. If anyone has any questions now, I'll pause for a few seconds for those to come in. But if not, please do send questions through after this event to events@owenmitchell.com. And also please give consideration to any other seminars you would like us to run in terms of specific topics or themes that you think would be useful. We don't seem to have any questions that have come through. This will be circulated, this recording of this event on YouTube through email through our events team, so it will be there. Please do raise any questions you'd like us to answer, and I'd like to thank our two other speakers today, and I wish you all the very best with your businesses in this difficult time, what is a really tricky time for the economy, and I hope everyone has a good day.